Good afternoon. Thank you guys so much for joining us today for Inheritance versus Legacy. Which one will you leave? Now, I know that sounds like a great title for the next Marvel movie, but in fact, it's the title of today's webinar, where we'll discuss the differences between inheritance and legacy and answer some questions and highlight some things to think about. So before we actually jump in, of course, we have a couple of housekeeping items to talk about. This webinar is really intended to be educational in nature. It's not considered to be financial or legal advice. Everybody's situation is unique, it's different. So for proper advice for your situation, of course, set up an individual consultation. We're happy to talk to you. Any questions that you may have along the way, feel free to write them down. You can use the Q&A here in the webinar. We'll see those questions and we'll do our best to answer those at the end of the webinar today. Lastly, Granite Harbor Advisors and Dean Law Firm are indeed exclusive and separate entities. So, who are we? My name is Dale Shaw with Granite Harbor Advisors. I'm a wealth manager here, and really our goal here at Granite Harbor is simple. It's to help families live their best lives. We have a lot of experience with helping families navigate through difficult decisions associated with owning businesses, retirement planning, legacy planning, which of course is today's topic. And we do this through comprehensive financial planning, serving really as the CFO for the family so that you, the CEO of the family, can make informed decisions. We also help families manage investments and helping with selecting and implementing appropriate insurance solutions. I'm very excited today to be joined by Miss Julia Dean. Thank you, Julia, for joining us today. Julia is from Dean Law Firm. She's the managing attorney and founder of the Dean Law Firm, whose practice is focused in the areas of estate planning, probate, and elder law. She has over 30 years of experience and founded the Dean Law Firm 15 years ago to provide a different kind of legal experience for clients. They strive for the highest of excellence in their work while providing their clients with the care and compassion they would want for their own family. Their efforts have been recognized in multiple awards for client care as top attorney and estate planning law firm in our area, as well as statewide, nationally, and internationally. Securing a thoughtful and excellent legacy for their clients is their passion. So thank you, Julia, for joining us today.
Thank you so much, Dale, for inviting me. It's an honor to be here.
All right, so as we like to say, the only thing that you need to do in order to leave an inheritance is to pass away. But to leave a legacy really requires thoughtful planning. So Julia, this first question, what is legacy? Can you tell us a little bit about that?
Well, legacy is not just who gets what of our stuff, but it involves leaving a legacy that lasts oftentimes to the next generation and future generations. It looks at how our beneficiaries and our loved ones receive our assets. We want to protect them, not only now, but for future generations. And so this includes creditor protection, divorce protection. It can also oftentimes does involve tax planning as well. So we're keeping those assets protected from estate or death taxes now and when it passes on. But it also encompasses so much more than just the financial side of things. It encompasses our own values and our beliefs, what we contribute to the community, how we want to have that continue on, and maybe some of our charitable giving even. So our legacy is being made now during our lifetime, how we live our lives out and how we plan now for the future. So it continues, we want to have that family continuity that is a positive continuity and that we have harmony in the family. So most people and families that we work with are very concerned about the kind of legacy that they leave behind. And in order to leave an excellent legacy, like I think we all want, strategic pre-planning is required.
Yeah, thank you so much. Well said. We totally agree. Good planning is one of of course, the core things that we do for our clients. And so, what does good planning look like? If we're to say what is good planning for a legacy planning actually answers three questions: where does my stuff go? What are the rules? And who is in charge? Now, having a will or a last will and testament is certainly a starting point for your legacy plan. But as we dig into these questions a little bit more, you'll see that there's additional tools that can help with, building your legacy plan. So let's take each one of these just one at a time. First one, where does my stuff go? So there's only three places that our stuff can go after we pass: family and loved ones, who we deeply care about; charity, who we also care about; and the IRS, who we may not care as much about. I think we all want to limit the amount that really this last party receives. And so what we're going to do next is look at answering the next two questions. So what are the rules? Now, there's a couple of ways that we can make some rules. If we leave money outright, there's really no flexibility. And so the rules are just, they're just not really there. Or we can leave money in trust. And every trust has three parties. There's a grantor, there's a trustee, and then there's a beneficiary. And having a trust allows us to get to write some rules. So if you would like to establish some rules in how your assets are used, then it probably makes sense not to just leave assets outright. Now, Julie, I know this is your wheelhouse, trust planning. Can you give us any real life examples or some impacts of trust planning?
Yes, and you're so right. It's the kind of legacy that we want to leave. We can procrastinate, and we don't have this time deadline, but if we want to do more than just leave stuff, we want to have that legacy. We want to have some continuity. We're going to have some rules around it. And so, some of those rules, I think maybe best explain an example. So we had a couple that came in, and they had 3 children. And we needed to have different kind of rules of the road for each of them in their trust. So we had trust planning for each of them, but with different parameters. So they had a special needs child. So we implemented a special needs trust to hold the assets that he would be receiving. This allowed him to continue to receive the government assistance he was receiving in Medicaid and SSI benefits without disqualifying him for the government benefits. And then he got to supplement it with what his parents gave him. So he got the best of both worlds. He was able to utilize the same, especially the medical care with Medicaid that he would really need the rest of his life. But then there was a lot of things Medicaid doesn't cover. So the special needs trust just supplemented that and gave them more. But special needs trusts have very particular rules of the road. And so it had to be done correctly so that we wouldn't be disqualifying them for needs-based government assistance. Secondly, we had a child who didn't handle money very well. She spent like there was no tomorrow. She was creative, she was spontaneous, she enjoyed life, but she was enjoying life in the moment. She wasn't thinking about her future. She wasn't thinking about retirement. So they were really concerned about her when they were gone. How was she going to live if she wasn't really planning for retirement? So we created a lifetime trust for this daughter that someone else managed. So the trustee, we talked about 3 different types of people: the grantor, the trustee, and the beneficiary. So she was the beneficiary getting the benefit of this, but someone else was a trustee managing those funds and investing those funds. And so we had some boundaries around it. So we weren't giving a liberal standard during her lifetime. We wanted to make sure we were investing and growing those funds so that by the time her retirement came along, there were still funds there that would cover her retirement. So we put someone in place that we knew would be great with money and could handle that and would work well with her. We also put protections around that by putting into a lifetime trust. So we had asset protection for her. So if she had any creditors out there, they weren't going to be able to come and get the money that her parents gave her. So we had this protection around it. And we also gave her divorce protection by putting in this lifetime trust, because if she got divorced, and they were a little worried about that, so if she got divorced, the divorcing spouse wouldn't take off with the money and go to another spouse or part or all of it. So no divorce court can get to these kinds of trusts. So the parents were really happy about that, because they knew the inheritance they gave her would go down to their grandchildren and maybe down to future generations. And then we had the third child, who was great with money. He was a doctor, but we were concerned about malpractice suits. And so we had this, we wanted to give him the flexibility to deal with his own money. At the same time, we wanted to protect him. So we did a lifetime trust too, but we had a broader, more liberal standard. And we gave him the ability to be the trustee, the person managing those funds, which was great. So he had a lot of flexibility there. And only if there was a creditor situation or a divorce situation that came up would he need to appoint an independent trustee as a co-trustee during that period of time to keep the protections really strong. So the parents were really happy that they had in place something different for each of them, different rules of the road. We also made sure that they were tax plans. So as that passed to the child, it was exempt from death or estate taxes, and that it passed on to the next generation, also continued to stay exempt. So we were planning all that time, but even with the planning, there was still some money that was subject to estate or death taxes. So they loved their charities, they loved their church and their schools and some hospitals. So they wanted to do some different things there. So we set up a charitable remainder trust for anything that would be subject to taxes. So instead of going to the government, it would go to the charity. But we did a hybrid scenario because they still wanted to give as much benefit as they could to their children. So now we had an income stream for their children during their lifetime going through their trust. And then at the end of that, it went to the charities that they wanted it to go to. So they were able to do a lot of great legacy planning in their plans by thinking through what their desires were, how each family member had different needs and they had different desires for them, and they wanted to help them and not hurt them by just giving them money outright. And so those are the kinds of things we set up. The other things we set up were dealing just with their retirement account, which we'll talk about a little bit more later, but a way to protect those and give them the best tax treatment on it. So it just was a huge relief to them that allowed them to expand and amplify on their legacy farther than they ever imagined they could go.
Wow. Well, thank you, Julia, for that information. That was really that was packed with some great examples how trust planning can help families write some rules. And you also addressed really, it's a good segue to the next question, the who is in charge. You talked a little bit about the trustees and allowing either an independent person be the trustee or someone else be the trustee or an institution be the trustee. So let's go to the next question. Who is in charge? So, excuse me, in an outright distribution, the recipient is really the person who is in charge of what they receive. Once an inheritance is received, they have total and full control, like you mentioned. But also, like you mentioned, in a trust, we get to name the trustees or the person that helps execute the rules of the trust. The trustee can be yourself. It can be another person or institution or even the beneficiary. So Julia, can you take a moment to talk about who you can name as trustee?
Well, that's such a crucial consideration. And I know sometimes that's difficult for clients to even come up with who that is, because we want someone who you implicitly trust, someone who can manage funds and that will implement the desires that you have for your beneficiaries. And so sometimes an individual trustee is a good option because you have someone like that, but sometimes we don't have that person in place. And so we might start looking towards more of a professional trustee. So that could be a corporate trustee who's a third party, will have, They are not influenced by the family or that beneficiary. They can make independent decisions. They're good at saying no, and we may need to say no, but they're also good at just really investing the money well. So although they have that fee with them, oftentimes they're well worth it because of their ability to deal with difficult beneficiaries. Or maybe we just have a complex estate. We have a large estate, or maybe we have one that has a lot of business interest or real estate interest. Those are all reasons why we might want a corporate trustee to step in. Remember, they're bonded and they're insured. So that really keeps us protecting our assets and our beneficiary, so that if something did happen, we had a bad corporate trustee, we have some recovery against them too. So a lot of my clients like that because they do have a lot of money at stake that they don't want to see wasted away. So they want someone professional who knows what they're doing to handle that, and that they're insured in case something goes wrong. Now, as we talked about in the example before, the child who's great with money, they could be their own trustee. And that gives a lot of flexibility. And we have some parameters in there in case there is a creditor or whatever to keep that creditor protection and divorce protection very strong. Sometimes, though, maybe we want to train our child, as they get to be an adult, how to handle their own money. They're not quite there yet. So we might allow them to become a co-trustee of their money, their trust fund, to manage it for a while. Maybe they start managing it as a co-trustee with a trustee that you do trust for, maybe at 25. And then at 35, they could become their own trustee. Maybe we don't know if they'll be right then. We could leave it to the discretion of that co-trustee that you do trust to go ahead and allow them to name them as sole trustee if they're ready to be it. If they're not, they'll continue to maintain the co-trusteeship. So it's a great way to train a child or a loved one to be able to take over their trust.
Yeah, that's a great idea. Very helpful. Thank you, Julian. Now that we've really addressed a little bit about the three questions: where does my stuff go? What are the rules? And even who is in charge? Let's talk about, what are some common things that could derail an otherwise well-intended plan? And the first thing that could derail a well-intended plan is taxes. This is the third party that we want to try to limit as much as we possibly can. And there's several different kinds of taxes. We have, especially in large retirement plan balances, we have taxable estates, we have large capital gains, just to name a couple. It's really important to have a good understanding of how much of your plan is headed to the IRS and what can be done both now and in the future to help mitigate that. There's really so much to be said on this one topic. And it's also where our firm has a pretty high focus on helping reduce the lifetime impact or lifetime tax impact for plans. We like to actually stress the importance of tax diversification, which is owning assets in different categories with different tax treatments: pre-tax money, after-tax money, tax-preferred money, just so that your legacy plan is actually aligned with your wishes. There's numerous strategies to assist with that. Just to name a couple: multi-year partial Roth conversions, which help spread and lessen the income tax burden over your lifetime and your heirs' lifetimes. Another one, helping create liquidity for taxable estates to help pay estate taxes that may be due. Another one, what to do with assets that have large capital gains. Charitable giving, as you mentioned earlier. These are all just examples of some things that we need to think about, that we can implement to help reduce taxes over time. So what form are your assets in now? So just speak, if you don't mind, Julia, for a minute, how to minimize the tax impact. You talked about qualified plans. How do you minimize the tax impact of qualified plans?
Well, I see most people have two large assets. They have their home, is usually one of their biggest assets, and their retirement accounts, usually the second biggest asset. So dealing with the retirement assets well and in the best possible way is a great way to ensure we're leaving an excellent legacy. So if we're doing it in a thoughtful way, we can change inherited retirement funds from being one of the worst assets that we give our loved ones to be one of the best assets that we can give our loved ones. The reason why they start out as being one of the worst assets is because they still haven't had income tax paid on a lot of this. So if we have traditional funds, those taxes have been deferred and they may not have been paid out yet when it comes to us as an inherited IRA. And so because of that, we want to be able to continue to stretch out the fund. So if we can change that into one of our best assets because we're dealing with it well, we can amplify our legacy by allowing that compounding interest, tax deferred or tax free, to continue throughout their lifetime. So we utilize retirement inheritance trust to provide the best tax treatment. So we can, if it's a 10-year or maybe it's a lifetime stretch, or maybe it's a hybrid kind of scenario where we're doing part lifetime plus 10 years for our minor children, we can get the best tax benefit, but we can also layer on top of that all the trust benefits, which would be the asset protection, the divorce protection, and additional tax planning. That would be the death taxes. So when it goes down to your child in a retirement inheritance trust, not only do they get to defer the income taxes or have tax-free growth, compounding growth, but they have that passed down to the next generation. So whatever they have still in there and all the growth in there will pass down to the next generation as state tax-free.
That's a really great strategy. I'm sure families can be really helped with a strategy like that. So another thing that can be a challenge to a well-intended plan is family conflict. So this can completely derail an otherwise well-intended plan. So what are some common causes of family conflict? Well, we've got the desire to treat an illiquid asset differently. For example, two siblings fighting over selling a business or selling a house. One doesn't want to sell it, or one doesn't know how or what to do. Or another example, one kid picks up expenses of long-term care for mom and dad, and they've been taking care of parents for years, and not everyone has really helped to pitch in. How to address those issues ahead of time so that siblings are not fighting over assets. Julia, can you answer that question?
We find that the best way is really, first of all, having a well thought out plan. So we want to anticipate the issues that might arise and address them before they happen. So if we can do that by pre-planning that in your estate plan, I can't tell you how many issues we've avoided by just dealing with it right up front. In that plan, we want to make sure we have very strong no contest provisions. So if that one child or one beneficiary contests the will or contest a trust, they will lose it all. And so that in itself keeps people from suing and having contest on that will or trust. Another big area is just personal property. I can't tell you how many times some little family heirloom that's not worth anything, or even a piece of junk that anyone else would throw away, has caused a huge issue within the family, has torn the family apart. So just dealing with that personal property, all the stuff, will make a big difference in eliminating or minimizing that family fighting afterwards. So I would hate to see as a family just ripped apart because of something silly like that, or because we haven't planned. As you mentioned, Dale, too, there's also a way to equalize assets, and life insurance can be a great way to do that. I know you work with your clients on that, so that's something really to explore. When we have an illiquid asset like a business asset, and one child's involved in the business, but the other one is not.
Yeah, these things are so important to address and pre-plan, like you talk about, just ahead of time, so that there's so that we limit the family conflict as much as possible. That really leads us to the third challenge. I'm sure there's many more, but the third one we'll talk about today are just some non-financial aspects of legacy planning. Whatever type of person that you are, money really only makes you more of kind of what you already are. What I mean by that is if you're already a very generous person, then money, an inheritance, a legacy is just going to make you more generous. Greedy, money is going to make you greedier. And so thinking about that, a good legacy plan can help amplify the values that you want to pass on and continue to instill in your kids, your grandkids, generations after you, and ensure that those values remain based on the hard work that you've already put in.
And Dale, that is so true. I mean, a legacy that lasts really encompasses all aspects of our lives and the values we live by. And so as we train our children, throughout their lifetime, and we see the kind of person they are, we can help kind of adjust things and the rules of the road to help amplify good values that you wish to instill. But we are more of usually what we are already, and so our values really do come out there. And so thinking about the legacy and that impact on other people is so important.
Yeah, this is such a thing that we all need to think about. It's not always easy or fun to think about legacy and the fact that we're not going to live forever. But the types of legacy planning that we talked about today and that most people really want requires a team. It takes a team. It requires a team of professionals. I know you like to call it the three-legged stool. You want to have a good estate planning attorney. You want to have a good financial planner. You want to have a good tax professional or CPA. And that three-legged stool really helps to support a good legacy planning foundation. So I think we actually have a couple more minutes left for some Q&A, some questions that I will make sure we get to for the last 3 minutes of our 30 minutes today. And the first one that I actually see is, I already have a trust, but I thought it was just for creditor protection. Okay, yeah, so there's numerous kinds of trusts that are set up for multiple reasons, including non-legacy planning reasons. For example, what this one sounds like is a revocable trust, which is set up as sort of a will substitute. It offers better disability protection, maybe not creditor protection for a revocable trust. It offers a level of anonymity and probate avoidance. So there are trusts that are for legacy planning, and there are trusts like a revocable trust that are not for legacy planning.
And just to add on to that, inside that living trust, we can do some creditor protection and asset protection and other things kind of in sub-trust within a revocable living trust. But I think that is a common misconception that a living trust provides asset protection, and creditor protection, which it does not in and of itself. But we can set up trust within it that would.
Yeah, that's great. One more question here before we sign off today. I think this one we should really address. So here's the question. What if I want to change my mind later because my goals have changed? We see this a lot. So that's a great question. Goals change sometimes. Certainly tax laws change and family dynamics can change. So reviewing your plans, your financial plans, reviewing your legacy plans every few years is a best practice. Just legacy planning or estate planning is it's a process. It's not a one-time event. So to ensure that there is flexibility built into trust and into your legacy plan so that they can change if needed. Do you have anything else to add to that question?
I think that's just so true. Just like with your financial planner or your CPA, having an estate planning attorney that can continue to work with you throughout the years, is your family attorney, can help the future generations. And that we're looking at it, it's not getting old or stale or working against you in any way, especially if the laws change. We want to make sure we're updating that and keeping that current. So this is a really good question, a good point that we do need to look at it every few years, or if you're situation changes, you get married, divorced, and there's a death in the family, you're hearing in the news a lot of things about taxes and potential tax laws. So it's always good to be current on that and coming in if this might affect you.
Perfect. Well, guys, it takes a team. We talked about questions. To wrap up for today, if you guys have any more questions or would like to speak with either Julia or myself about your specific situation, feel free. Contact us separately. Our contact information is on the screen. Lastly, this webinar has been recorded and it will be archived so that you can access it for reference. Thanks again, Julia, for joining us today and for your helpful insight.
Appreciate it. It was my joy.
You guys have a fantastic day and a great rest of your week.
Thank you. You too.